A key ruling to tell you about this morning, pitting Second Amendment advocates versus supporters of tougher gun control laws.
All right, let's talk about a win for the Constitution and a loss for the pearl-clutching, fear-mongering gun control lobby. A federal appeals court just ruled that the government can't arbitrarily deny law-abiding adults, yes, adults, the right to buy a handgun simply because they're under 21. And naturally, the anti-gun crowd is losing its collective mind over it.
A U.S. appeals court has ruled against a decades-old federal law that requires a prospective gun owner be 21 years old in order to buy a gun. The Fifth Circuit Court of Appeals in New Orleans found that such a law violates the Second Amendment, following a 2022 U.S. Supreme Court ruling which expanded gun rights. The appeals court found that people between the ages of 18 and 20 should not be prohibited from buying guns, saying that age group has the right to keep and bear arms. According to the organization Everytown Research and Policy, federal law requires a person to be 21 to buy a handgun from a licensed dealer and 18 to buy a long gun. There is an 18-year-old minimum for handgun purchases from unlicensed dealers and no minimum age for long guns. Many states have raised the age, barring handgun sales to people under 21 and long gun sales to those under 18, regardless of whether the purchase is from a dealer or unlicensed seller.
The ruling that should surprise no one except anti-gunners. The Fifth Circuit Court of Appeals ruled that banning handgun sales to adults age 18 or 20 violates the Second Amendment. Shocker. Turns out when you actually read the Constitution, there's no asterisk next to the Second Amendment that says only valid if you're 21 or older. Judge Edith Jones, who wrote the court's opinion, pointed out the painfully obvious. The Second Amendment protects all the people, not some of the people. Not only people old enough to rent a car without paying extra fees, all of the people. And guess what? If the government can draft you into the military and hand you an M4, then you're certainly old enough to buy a Glock to defend yourself at home. And before anyone tries to bring up some 19th century law to justify modern gun control, Judge Jones shut that nonsense down too. Because if your so-called historical evidence contradicts what was actually going on at the time of the founding, then it's not history. It's just wishful thinking dressed up in old-timey font. Now, predictably, the gun control lobby is panicking. Groups like Brady are crying that this ruling will allow teenagers to have easier access to handguns. And see, this is where this dishonesty really starts to shine. They love to lump 18, 19, and 20-year-olds into the teenager category when it suits their agenda, because the word teenager makes you think of high school sophomores sneaking out past curfew, not legal adults who can serve in the military, sign contracts, and get married. You ever notice how gun control groups never call 18-year-olds teenagers when they're talking about voting? Oh no, then they're young adults with voices that must be heard. But the second they want to exercise their Second Amendment right, whoa, slow down there, Junior. You're just a child. So which is it? Are they responsible adults when it's convenient for you, but helpless children when it's not? Or is it just that you hate the idea of anyone having gun rights, and this is the best argument you can come up with? The truth is, the ruling just restores the rights that these young adults should have had all along. The government has been treating them like second-class citizens when it comes to self-defense. Meanwhile, these same 18 and 20-year-olds can be sent off to war, taxed, charged as adults in court, and hold legally binding contracts. But buying a pistol for home defense, now that's just way too much responsibility. It never made sense. And it was never constitutional. The only reason this ban even existed in the first place was because Congress threw it into the 1968 Omnibus Crime Control and Safe Streets Act during a moral panic. And we're supposed to believe that 1968, a time when the government thought it was perfectly fine to outlaw entire races of people from certain parts of town and to let the FBI spy on civil rights leaders, was some gold standard of constitutional wisdom? Yeah, no thanks. And let's be real. If this case makes it to the Supreme Court, it's game over. There's no historical tradition of barring legal adults from owning firearms, and the government doesn't have a leg to stand on. At the end of the day, this ruling is a huge win for gun rights and a devastating blow to the fear-based narrative of gun control groups. Because no matter how much they screech about teenagers with guns, the Constitution doesn't care about your feelings. The right to keep and bear arms isn't a privilege, it's a right. And that right doesn't magically start at 21 just because anti-gunners wish it did. So, to the gun control groups losing their sleep over this ruling, maybe, just maybe, it's time to accept that your bad arguments aren't holding up anymore. One thing's for certain and two things are for sure. Politicians and tech giants don't want gun content to be recommended to you. And we're all fighting this culture war together. Now, you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together, we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.